Today we have somebody who is very special to me. His name is Subhash. He's an intellectual property lawyer in arts, and we just thought to quickly have a chat because nowadays there are a lot many infringements that are happening, and he's the one who guides us on all the matters. Subhash, great to have you, man. Uh, Subhash, it will be great to discuss and delve into some insight where you can give us information that how art galleries or artists can feel the importance of maintaining IPs and filing for IPs, because we see that a big miss. And then we also see there's a lot of counterfeits that are available when people want to buy or visit a particular gallery. They are not sure is the certificate also real or not.
Yeah.
So if you can just give us some perspective on that.
Well, from my experience in this field, I have realized that this sector, the whole art and craft industry sector, it's extremely unorganized. That could be a boon or a bane to the industry, but largely at the cost of the problems that the artists face. They somewhere not resolved, or there is no recourse to these problems because artist is generally found at the lowest level of the food chain. The industry is rather ruled by galleries or organizations or even government for that matter. It is very important to have this awareness about how the law protects your interest, what are the rights under law, and you being an artist or you being in gallery, how do you better serve each other's interest by staying under the ambit of law. Art law is, as a sector, as a practice that we practice, for several years now. We have noticed that there is clear ignorance of intellectual property rights, clear ignorance of contracts, having no understanding of issues like insurance, recovery, moral rights, performer rights, and these are very critical. Thinking from an artist's perspective, you put your heart and soul into your work. That, of course, that has its monetary benefit, but that also has a lot of emotions attached. And it's very interesting that the law in India that protect both your monetary interest as well as the emotional interest. So when we talk about moral rights, artist has something which is an inalienable right, the moral right. How many galleries or how many organizations consider or give or encourage the utilization of these moral rights? Just for example, when somebody has created an artwork and the gallery has exhibited that artwork, people click pictures and they post it or they make t-shirts out of it because they like the artwork. They just print it on their t-shirts. There is no credit given to the artist. There is definitely a commercial exploitation at times because these merches are also made available on a commercial basis, and neither the artist nor the gallery gets benefit out of it. So why it is happening is because there is clear ignorance of law, and you could have really monetized your artwork, your effort to even exhibit the artwork by having the proper set of law. Now, where is the law in this? The tickets. So when you enter a gallery to visit an exhibition, you buy a ticket. And if the ticket does not have a proper terms and condition to say that if you are clicking picture of A, clicking picture is prohibited. If you're clicking picture, then you have to pay additional so and so. As a kid, when we used to go to forts and other monuments, there's always an additional fee charge when you're carrying your phones or cameras, right? Why is it so? Because they know that you will replicate, or there is an intention to replicate, or to keep, or to store a visual imagery of that monument.
This is very interesting, and you know that I'm passionate about tourism, and I'm passionate about art. Having artworks as one of our IPs also. From explorer to revivalist, my journey has also transcended to see and understand when a traveler is taking a picture, for example, at Lodi Art District. There's a street art out there.
Correct.
What's the copyright thought line on that street art? Because artist who has made it is either an NGO or a private funding organization, but still art is there.
Yes.
And if you're taking a picture out there, what's the copyright?
Now, see, of course, there exists a copyright. Now, copyright as a misnomer, it says copyright, but it is not right to copy, right? But when we're talking about experiences or projects like Lodi Art District, where these artworks are painted, the murals are done for the benefit of public at large, then probably nobody is questioning or nobody is claiming a copyright. Nobody is enforcing those exclusive rights. So it is a deviation from the actual copyright as we see it in Section 13 of Copyrights Act, which is exclusive right to reproduce, exclusive right to create copies or issue copies. These are the rights. But when you travel through Lodi Art District and you find some nice mural and you want to click a picture in front of it, this is what the intention of probably the organizers, the people who are putting those murals in place. And that is why they are not sort of enforcing these copyrights. On the other hand, if I have commissioned an artwork, say our Golden Door, right? It's a commissioned artwork, and I have the right. If I want, I can stop people from taking pictures.
Okay.
Right? I can always do that. So if there is a mural that I have commissioned and it has a value which is probably I want to monetize that, then I can always enforce my copyright in that respect. Well, it is, it is not always important that because there is a right, you always have to enforce. But because there is a right, you can always enforce.
No, I understand that, because in tourism, we are also a bit of impact driven. And for us to do things which are more decorative, more aesthetically aligned to the places where we operate from, we want more and more people to visit. So there is a reason that the Golden Door is a Golden Door, because we want people to take pictures.
In the US or somewhere, there was a case where a fashion label did a photo shoot in front of a mural. The mural artist, they sued the fashion label saying that you have not taken the permission from us to shoot this video in front of a mural. So if somebody is aware of the right, they can always enforce it as well.
And this brings me to last question rather, because we will be having a storytelling session with you, with the chosen viewers, where they can ask, they can consult, that they can take your opinions. In tourism marketing, we see a lot of cultural symbols being placed.
Correct.
How relevant are they from the trademark or copyright standards? Because these symbols, sometimes they are under Creative Commons licenses, sometimes they are not. But how can one understand what to use and what not to use? And this I am asking from two reasons. One, you commission something on a digital platform, people just do cut, copy, paste, tend to, or create through AI. And we understand AI is a different segment altogether. But the true cultural symbols of ours, if they are used in the collateral, do we have to give credits? Do we have to mention? Or what do we do? I mean,
so classic example could be Taj Mahal being used for chai, right? Now, Taj Mahal is a monument which has its own, historical and so much significance otherwise. And when somebody used Taj Mahal as the visual Taj Mahal photograph as a trademark, then is that use in violation of certain rights of Taj Mahal? Now, Taj Mahal is, it's been so age-old building and monument. It is not a proprietary of anyone now. It is more in the public domain. But now when you use a public domain work to be associated with you as a proprietary trademark, then should you be allowed? Well, it is in a gray area, because if tomorrow somebody else wants to use Taj Mahal, they can also use it, provided they are not using it as a trademark. So far as the case laws or the judgments have proceeded, they have recognized Taj Mahal as a trademark, right? But specifically in an arbitrary manner, where for a tea you are using Taj Mahal, not for, say for example, a monument. That would have been a descriptive thing. Now, one need to understand that there's a difference between different types of intellectual property. A trademark is different from a copyright. So when we talk about Creative Commons, that license is largely with respect to copyright works. Works which are in public domain, there is no copyright on them. But works which are not in public domain, that is, they are still valid, subsisting, legit works, in which you can decide whether I want to retain all the rights with me or I want to give away certain rights so that people at large can benefit. And that's why when I decide to go with a Creative Commons license.
Then this brings me to another curious question, though I'm cutting a bit short here, is which we get to know and we understand as layman that there are books, if they are printed and they are done over 50 years, the shelf life,
Correct.
they are out of copyright.
Yes, lifetime plus 60.
Lifetime?
Lifetime of the author plus 60 years.
Lifetime of the author plus 60
why
years.
it is so? Because see, I have created something, at least my 1 or 2 generations should also bear the fruit of my efforts.
Okay.
So that is why it is assumed that in 60 years your generation will also fulfill their needs from your work.
And in that case, if somebody finds that book with the intention to translate it,
Yeah.
or reprint it,
Yeah.
they are open. They are
Open to do it because the right of translation is also your exclusive right, your copyright. And the age of a copyright is lifetime plus 60. So if somebody has died in 1950, so in 2010 or whatever, that right will exhaust. The work is in public domain. You can, you can reprint it, you can translate it, you can do adaptations in terms of, say, a movie has been created or theatrics has been done on it. You can do all that thing,
and you can further, earn money out of it.
Yes, of course, for the prints. So when you read, say, Bhagavad Gita, or when you see Charles Darwin, or when you see Van Gogh's painting, all these are in public domain, and people are copying them left, right, center.
Yeah.
Right. But when you see a John Grisham, when you see a Ruskin Bond, they are still in public. They are still not in public domain. So that is counterfeit. So when you go on all these crossings in Delhi, and people carrying a whole, a block of novels, they are counterfeits for sure. But yes, if there's a novel which is maybe a Bhagavad Gita, that work is in public domain and it's allowed to. It's permitted to make copy of it.
No, I think it's amazing, Subhash. We can go on forever on this. But thank you very much for taking time to do this snippet. We will be soon announcing a full-fledged podcast with Subhash on the art and art galleries as a subject, or linking all the copyright, trademarks, infringement methods, and look forward to showcasing that sometime soon.